Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Today we're going to conclude a 3-episode series, consecutive series, looking at multiple documents that were filed by the Media Coalition in the case styled as Idaho versus Koberger on May 1st, 2023. The final two that we're going to address are the interveners or the Media Coalition's motion to vacate the amended non-dissemination order that Judge Marshall entered on the 18th of January 2023, and a memorandum of law containing precedent, containing case law from both the United States Supreme Court and the Idaho Appellate Court, statutes, you might cite to court rules, other authority, showing that, Judge, we believe that the facts of the case here, as applied to this precedent, shows us that it is proper for you to vacate this ruling that you made back in January. So what they're saying here, as the interveners, recall, they're not here for the distance, they're not here for the entire case. As they said in their motion to intervene, we're just here for this limited purpose, to try to persuade you, Judge, to set aside this non-dissemination order because it is vague, or it is too broad, or it is unduly restrictive. It's not narrowly tailored. It violates First Amendment privileges that we as the press have under the United States Constitution. That also violates privileges under the Idaho Constitution. Now, they also reference in the motion that the Idaho Supreme Court says that when a gag order does these things, it's overly broad, it's unduly burdensome, it's too restrictive on speech, that it does violate free speech. Not in this case. They're speaking generally, the Supreme Court of Idaho, and making that ruling because, recall, if the coalition would have won their battle before the Idaho Supreme Court, they wouldn't have had to intervene here. But these are the arguments that they're making. It's unduly burdensome. It goes too far, Judge. In the court, in rendering its ruling and entering this gag order, said, we recognize that there is a constitutional right of free speech, freedom of the press, but Mr. Koberger also has a right under the United States Constitution, under the Sixth Amendment, to a fair trial. And the concern here is when you have the First Amendment and the Sixth Amendment basically butting heads, you got the press over here arguing freedom of speech, freedom of the press. You have defense arguing, well, Mr. Koberger has a right to a fair trial. And if people are reading, and the jury pool is reading all of these prejudicial stories about him that the press is reporting, well, the jury pool might not remember when they're deliberating whether they heard something because they watched a TV program somewhere, or if they heard something while in court. So that's where you've got that rub. You have the rub of the press saying, we can't do our job. This gag order goes too far. It is unconstitutional. You should set it aside, versus other issues, other constitutional rights, namely Mr. Koberger's Sixth Amendment right to a fair trial. The memorandum of law cites to specific U.S. Supreme Court cases. It cites to Idaho appellate cases and other legal authority. And what the coalition is arguing is when you take this legal authority, you apply it to the facts here, Judge, you must conclude. It is proper for you to conclude this gag order goes too far. It should be vacated. It should be declared null and void. That is what the coalition was looking for in filing this motion to vacate. That will conclude today's episode of the Indie Zone. Thank you for your time and your attention today.